Therefore, such an injunction would violate Arizona law. For one example, ARS 12-1802 subsection 4 provides that courts cannot issue an injunction that prevents the enforcement of a statute for the public benefit, such as the public records laws. The relief requested by the district, an injunction against harassment, would conflict with the district's statutory duties to produce public records upon request. The district is requesting relief that violates the plaintiff's rights to access public records and their rights to free speech and petition as well. Repeatedly in their briefings, the district describes the plaintiff's request as baseless. However, as I noted, Arizona courts have explained that it is well established that the requester's need, good faith, or purpose is entirely irrelevant to the disclosure of public records. Therefore, the description of the request as baseless is inapposite to this action. What is more, Arizona case law provides that 12-1809 injunctions against harassment, which is what the district is asking this court to issue, quote, cannot be used to restrict protected political speech, and one of the harassing acts they allege is the maintenance of a website that's critical of the government. What is perhaps worst, however, is the following. Imagine the relief is granted. The court issues an injunction against harassment against my clients for the benefit of the district. The penalty for a violation of an injunction against harassment is, or at least can be, arrest. When the district feels harassed by one of the plaintiffs, perhaps for placing a baseless records request, or perhaps for posting something on their website that the district finds threatening, the district would have the power to call the cops or to call the sheriff and have one of the plaintiffs arrested for violating the injunction against harassment. And that is to say nothing of the applicability of the statute itself, Your Honor. The government is plainly not a person under 12-1809 and is therefore not entitled to benefit from the injunction against harassment statute. We've extensively briefed the court in our filings on this issue. Furthermore, Your Honor, the Arizona Supreme Court actually just a few days ago on November 30th, Wednesday of last week, issued a ruling that holds that the word person in a statute does not include a government entity unless otherwise expressly indicated by the legislature. The court also recognized that the general definition of person in the statutes, which is cited by the district, does not include government bodies. And I brought copies of that case for the court if you'd like to see it.
What's the citation, counsel? If you have a copy, you can hand one to counsel, and I'll take one. That may be the easiest way to.
Your Honor, I unfortunately do not have a citation, just because I just got it.
Okay, but just for the record, the case that you've handed me is the estate of Jacob Braden versus the state of Arizona, and this was an opinion, I believe, that was issued last week, and I did see that opinion. So the citation will be available, I'm sure, shortly.
Sure.
Thank you.
Thank you, Your Honor. Anyway, the point there is simply that the 12-1809 statute cannot operate to benefit the government. The word person does not encompass a government body in the context of this action. As I noted earlier, Your Honor, the district's counterclaim asking this court to issue an injunction against harassment is an appalling legal maneuver. It's an attempt by the government to deter public participation in the political process, to evade the principles of operational transparency in government, and to preclude the disclosure of records that likely contain evidence of government maladministration. So for all the reasons I've just explained, the counterclaim should be dismissed. The public records also ought to be disclosed. That's all I have, unless the court has any further questions that I can clarify.
I don't think I do at this time, Mr. Sintakis.
All right.
Thank you.
Well, thank you, Your Honor.
If it pleases the court, I'm Bob Lynch, and I'm here on behalf of the defendants. And this is, as the court noted, an OSC proceeding, not a motion for summary judgment argument. The comment a couple of things on what plaintiff's counsel said. In talking about overly broad and vague requests, and that is a standard under the public records law that allows denial of a request for that very reason. It's not a category of public records being